Senate Bill 155, adding harboring or concealing a person who has violated terms of probation to the crime of obstructing apprehension or prosecution. With that, a brief from the reviser.
Thank you, Madam Chair. Senate Bill 155 amends KSA 2159-13. That's the crime of obstructing apprehension or prosecution. The current elements there of the crime are knowingly harboring, concealing, or aiding any person who either has committed or been charged with committing a felony or misdemeanor with the intent that that person avoid or escape arrest, trial, conviction, or punishment, or that person is being harbored, is required to register under the Kansas Offender Registration Act and who's not in compliance with those requirements with the intent of either getting out of those registration requirements or avoiding arrest or trial for that. This bill would add a new element to that crime, which would be knowingly harboring, concealing, or aiding any person who's alleged to have violated the terms and conditions of probation, assignment to a community correctional services program, parole or post-release supervision, conditional release, or a suspended sentence. And violation of this new element would be the same as a violation of the element in subsection A1, which current law is a severity level 8 non-person felony if that person harbored is charged with a felony, and it would be a Class C misdemeanor if that person is charged with a misdemeanor. And I can take any questions.
Thank you. Committee, any questions? All right, then we will have a full day today, so I am going to ask that each of our conferees on the bills that we are hearing today limit their testimony to 4 minutes. And I will, if you'll look, I will hold up the manila folder to indicate you have 1 minute remaining. So if we could work with that, that would be appreciated. And we're going to first invite proponent conferee Missy Schoen on behalf of the Kansas County and District Attorneys Association on WebEx. Please introduce yourself and welcome to committee.
Thank you, Honorable Chairwoman Warman, members of the committee. My name is Missy Schoen. I am the Phillips, the Phillips and outgoing Norton County attorney. I have submitted this proposal on behalf of the KCDAA board as it became known to me last year that it was not a crime of obstruction or of interference of apprehension if a person had a warrant for a probation violation or a post-release violation. As the reviser statute, it adds the language for those persons who are alleged to have violated the terms and conditions of probation, assignment to a community correctional services program, parole or post-release supervision, conditional release, or a suspended sentence. That exact language was taken from the sentencing statute, KSA 216804, for the purposes of this. I think it's important for the committee to know that these individuals have a warrant because they have allegedly violated probation or post-release, meaning they have been sentenced, they have been convicted of and been placed on probation. Their sentence was suspended. They were given a chance at probation, and they have done something that has created the need for a county attorney or a district attorney to file a motion to revoke, and a judge has found that those allegations are probable and has issued a bench warrant for that defendant's arrest in the case of a probation violation. For a post-release or a parole violation, that is done through the Department of Corrections, and those warrants are issued through them. I think it is important to note, as stated in my written testimony, more likely than not, it would be my assertion that when an individual has a warrant for a post-release violation or a probation violation, they have a very good idea that that is out there. An individual or a defendant who was on post-release or parole through the Kansas Department of Corrections can actually look themselves up on the Casper website, and it says right there, DOC warrant issued, whether or not that warrant has been served. The minute it has been issued, that is public knowledge to anyone, including the individual. There's also concerns that with the new electronic filing and Odyssey system, a state individual can be made aware that they have that active warrant. They probably also been told by their probation officer, hey, you're cutting it close. It's time to get serious about this or there will be issues. And I would also assert then that a lot of times these individuals, if they've been to the Department of Corrections, have serious felony charges underneath them. And as stated in my written testimony, this became known to me this summer when we had an individual who had a post-release warrant. We knew he was in town. We had been unable, or law enforcement had been unable to apprehend him on his DOC warrant. Law enforcement were called to the home because of a domestic violence concern by a minor
1 minute.
child. And they found him hiding in a back room. And a day or two later, following his arrest, there was a gun found in the exact area where he had been hiding. We don't know if it was his. The owner of the home said it was, but that was a large safety concern for our officers. So I would ask that the committee pass Senate Bill 155, and I would be happy to stand for any questions. Thank you.
Thank you, and that was great timing too. Appreciate that. Do we have any other persons wishing to testify as proponents of the bill? Then we will open it up for any questions. Any questions? I have one question for you. I understand that the bill is talking about alleged to have violated the terms. So we're talking about a bench warrant has been issued after the judge has found probable cause to issue the warrant, but they haven't been found by a court to have violated the terms and conditions of probation or assignment to a community correctional services program, yet parole or post-release supervision, conditional release, or suspended sentence. Is that right?
Yes.
Okay.
And that would be a different hearing and a different a matter from their other case, from this new matter that Senate Bill, a new matter or a new crime that Senate Bill 155 would create.
So we're creating a new crime, and I understand it's important that we not obstruct apprehension or prosecution. And so that's what this bill is aimed to do. But are we certain that if it's a bench warrant, that the person you've talked about, the person would know that there's a bench warrant out, but have they been served with the bench warrant to know that? And we're not really talking about the person who the bench warrant is about. We're talking about someone else, and that the someone else would have to, in the bill, the statute with the bill would require you have to know that the person is alleged to have violated the terms before you could be charged with this crime.
Yes, ma'am. And I would assert that it is no different that a defendant is alleged to have violated the terms and conditions of their probation and has a bench warrant or an active warrant than a person who has committed or has been charged with committing a crime and alleged to have committed a crime for subsection 1. There has been no finding there either of whether or not the person is guilty of a crime. They have a warrant for their arrest, no different than the new subsection 3.
I don't mean you have been found by a court to have violated the terms. I mean you as the defendant alleged to have violated the terms. Do you have notice of the bench warrant being issued?
You can have notice if you look or if you have been advised. There are issues.
Well, does a one who's alleged, do they have an affirmative duty to go look to see if there's a bench warrant?
No, they don't, Your Honor.
Right.
The language is pulled from the sentencing statute. And again, if you've committed a crime or have been charged with committing a crime, there's a chance you're not aware of that either.
Right, because you're not required to show up unless you've been properly served with notice.
Yes. Yes.
Right. Okay. And then again, the person who would be charged with this new crime wouldn't be by law required to have any notice that there's a bench warrant out. Wouldn't be required to have received service of the bench warrant by the issuing court or by the prosecuting attorney?
Yes.
Okay, okay. I'm just trying to understand the circumstances, and I'll ask offline kind of if our research department could look to other states have this same crime in law. So thank you. Senator Titus.
Thank you, Madam Chair. I'm curious on the drafting decision here. It seems like this is broader than exceptions 1 and 2 because it doesn't include the with intent that such person shall avoid or escape from ... And this casts a wider net than the other exceptions here. What was the decision process in leaving that out of number 3?
I thought of that earlier this week when preparing my testimony. The first decision, or the first thought, was to add the correct language. So pulling that from the sentencing statute 216804, there's probably a need for that to be added.
Thank you.
Other questions? Not seeing any, then thank you for your testimony. Appreciate it. Next, we're going to have neutral testimony from Megan Milner, Deputy Secretary, Kansas Department of Corrections. Please introduce yourself and welcome to committee.
Is this on? Oh, it's on. Madam Chair, committee members, thank you very much. I'm Megan Milner, Deputy Secretary with the Kansas Department of Corrections. We are here to provide neutral informational testimony on the proposed bill. KDOC very much values the partnerships that we establish with support persons and family members of individuals who are on parole specifically, but also probation. And many of our supervised individuals rely on family or support persons for housing when they are releasing from facilities. And one of the unintended consequences of this bill may be that family members or support persons would be less likely to accept them into their home as a part of a residence plan if they could be held legally responsible for the supervised individual's actions. Additionally, this may create a safety issue for those family members or support persons in the home if a supervised individual believes that they're going to be reported by that family member or other person in the household. And with that, I'm happy to stand for questions.
Thank you. Do we have any other persons wishing to testify as neutral? Do we have any questions? All right, then we will invite opponent conferee Emily Brandt and Jennifer Roth. We'll just take one at a time.
It's just me.
From BIDS Legislative Committee, Kansas State Board of Indigent Defense Services. Please introduce yourself and welcome to committee.
Hi, my name is Jennifer Roth. I'm a member of the BIDS Legislative Committee. You have my written testimony. I want to start by clarifying something. The proponent talked about this bill throughout as though the person who is on supervision is going to be punished with this crime. That's not how it works. This crime covers other people who provide aid, harboring, or concealing of another person. It is not currently a crime to not turn yourself in if you have a probation warrant. It's not a crime to not turn yourself in if you have a parole violation. If that's what you want to make a crime, as it sounds like the proponent is asking you to do, I would suggest you ask for an amended bed count, because that is a whole nother matter. What this bill does is it makes another person have to rat out the person that they are trying to help that is on supervision. I really appreciate Megan, I already forgot her last name, being here to explain how this works. It's the same sort of way for people on probation. People that provide supervision, parole officers, probation officers, they count on people having pro-social contacts and support systems. And if this bill passes in this form, those are the folks that get punished, not the person that might have a warrant. So I just wanted to make clear who this language really targets, and it doesn't sound like it's who the proponent wants to target. By the way, it is already a crime if you are the person with a warrant, whether you're on probation or a new case or parole, if you're the person with a warrant, it's already illegal for you to obstruct the service of that warrant. You don't even have to know if you have a warrant. And it's still illegal for you to interfere or obstruct in the service of that warrant. And if it's a felony warrant, it's a felony for you to do that. So that's an existing offense called interference, and it's a level 9 felony if you have a felony warrant. So I just wanted to be clear about what the bill was about, who it covers, and I just don't think that this legislature wants to get in the business of punishing people's support systems and pro-social contacts, and that you don't, and again, people that have the warrant or not, or alleged to have violated their probation, which by the way, I don't know how a third person knows that, because I thought it was illegal to disclose that somebody had a warrant until it was served, but whatever. It sounds like maybe we're all figuring it out here, but the fact is that if somebody with a warrant, whether they know it or not, obstructs or interferes, that is a crime today, and it is a felony. So it is our hope that you do not move this bill forward in any form, because it would represent a major shift in public policy, and also set up people that we need to be available and be supportive of people who are on supervision. I'd be happy to answer any questions.
Thank you. Do we have any others wishing to testify as opponents? Then we'll take any questions. Are there any questions? I have one. With the bill would require that the person to be charged with this new crime is knowingly aiding the person who has a warrant, but would that person also need to know, to be charged with this crime, that the person they're helping has a bench warrant out for them? Or is just the knowingly aiding, you know you're aiding the person?
Right.
So could you discuss that a little bit?
So at first I thought, after I filed my written testimony, I started thinking about it. I'm like, maybe I was a little harsh about the drafting, but I've decided that I was not. Perhaps I was not harsh enough, because there is case law, and there's another statute that we have about levels of culpability, where if I had to, maybe I would be able to argue that you have to know the person is alleged to have violated their probation. And so perhaps the knowingly from the first part can, and I'm not talking about you, Natalie. I just want to say, like, it's clear that the proponents were trying to go for something, and so it's really my frustration, I guess, is with the proponents. But so to answer your question, number one, I could make an argument, and I have made an argument in the past, that the knowingly should transfer to the new language as well, that I would have to know. But I would want to back up and tell you, you don't even have to have a warrant to violate this. This says that we're alleged to have violated their probation. Now, granted, that normally implies a warrant, but your probation officer could send you a letter and say, you haven't reported since such and such a date. If you don't come in by this date, then I'm going to show cause you or whatever. That's also an allegation that you violated your probation. So I'm not so sure that this language even requires a person to have a warrant. And again, I don't know how a third party knows that in the first place. But even if we take the knowingly from the first part and put it with the new language, it doesn't change the fact that, as you pointed out, maybe Representative Titus or Senator Titus pointed out, it does not have the specific intent language. And so even if it requires you to knowingly aid somebody, which you know you're doing, and it requires you to know that the person has alleged to have violated their probation, it does not require that you are helping them with a specific intent to help them evade the consequences.
Thank you. Yes, Senator Clays.
Thank you, Madam Chair, and thank you for your impassioned plea here
Sorry,
today.
I just get very nervous when I come here.
No, I can tell this matters a lot to you, and I have to say you made a lot of good points, especially the harboring, because harboring is, just having someone at your house. And so my question is, it seems to me that the people proposing this have some specific situations in mind where someone is actively helping someone abscond. Are there any redeeming qualities with this bill that we could improve it in such a way that maybe gets to that piece while allowing people to help and not necessarily be actively trying to, obstruct justice?
So maybe, but I guess even in the example, this is where I thought the proponent's final example was going, was the person hiding in the house. I thought maybe it was going to go to like the person that was letting them hide in the house or something, but it didn't. So let's say that in that scenario that the officers had come to the door and said, we're here to serve a warrant on John Doe. And the person that's lived there said, oh, he's not here. I haven't seen him in 2 weeks. You, under existing law, can already charge that person with interference because they have lied. Now, they have a constitutional right to stay silent. If they'd said, I'm not talking to you, I'm not letting you in my house, then they arguably haven't committed a crime. And so maybe you'd have to tailor this to if you wanted to get that person. But in the event that that homeowner said, he's not here, then they can be charged under current law with interference. So I guess my answer to you is, I feel like there's other ways to get at it with existing law, or there's a way to get at it with existing law. But if you want to, if you really do want to say that, well, he was living at your house that whole time and you didn't tell anybody, then you're going to have to write a law that puts an affirmative duty on a third person to tell somebody that somebody's there when the person with the warrant themselves doesn't have to do anything, or it's not a crime to do anything. I don't know if that made sense.
Can I get a follow-up from the proponents, or is it too late for proponents? Have we already done that?
We've got a pretty busy
Okay,
schedule
all right,
today,
that's fine,
so.
Madam Chair. I just wanted to get an idea of, because I like to be charitable and think the proponents probably had the best intentions in mind here, but it seems that it may have gone off the rails a little bit, and I was wondering if there's just something we can do to maybe improve it, but thank you.
And as a closing note, my contact info is on here if people wanted to email me with any additional questions or explanations. So thank you for your time.
And of course, I'm sure the proponent would be available for offline discussions as well, so, and about the bill. But with that then, since we don't have any other conferees, we will close the hearing on Senate Bill 155 and open the hearing on Senate Bill 244, prohibiting a compensated surety from making loans for certain portions of the required minimum appearance bond premium. With that, a brief from the reviser.
Thank you, Madam Chair. Senate Bill 244 amends KSA 222809B. That's the statute about the regulation of compensated sureties. Current law there in subsection D requires a compensated surety to charge a minimum appearance bond premium of 10% of the face amount of the bond. And then they're only allowed to post that bond after they have received at least half of the required minimum appearance bond premium, either by cash, check, credit card, debit card, wire transfer, bank transfer. This bill would provide that a compensated surety shall not provide a loan for that portion, that half of the 10% of the minimum appearance bond premium. Any loan obtained for the purpose of paying that portion shall be obtained from a financial institution that's properly licensed, and a compensated surety shall not be an owner in whole or in part or in any way affiliated with a financial institution that makes loans for the portion of paying that half of the 10%. And I can take any questions.
Any questions? All right, then we will invite proponent conferee Stephen Owens, Kansas Senator, District 31. Please introduce yourself and welcome to committee.
Certainly. Thank you very much, Madam Chair. And a portion of this I'll only say once. First of all, I miss being on Judiciary. I served for 6 years Judiciary in the House and miss the work that you guys do here. In full disclosure, this is an industry in which I've operated for 25 years. So keep that in mind, kind of as a bit of an industry expert. I've worked for many years to try to increase the professionalism of this industry and ensure that our laws fulfill their judicial obligation to the court. I normally wouldn't testify, however, I don't sit on this committee anymore, so I'm here to do so. Simply put, SB 473, we overrode the governor's veto on that last year, creating the minimum bond premiums. Unfortunately, sometimes trailer bills are required to clarify what is and is not acceptable, and there are a few actors out there that are acting as lending institutions to circumvent that 5% requirement. And so this is just a follow-up to clean that up, just to clarify that that was not the intent of the law that passed last year. So I will stand for questions.
Thank you, and I enjoyed serving with you in the House on the House Judiciary Committee. So thanks for your testimony today. We also have proponent, if you'll stick around if there are any questions, that'd be great. We also have Shane Rolfe, Vice President, Kansas Bail Agents Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chairman. Or Chairwoman, sorry. My name is Shane Rolfe. I'm the Executive Vice President of the Kansas Bail Agents Association. I would largely second what Senator Owens had to say about this. We advocated for passage of Senate Bill 473 for just this purpose. We think that by putting this in here, it creates some protection both for our industry and for the customers of our industry. We don't want them getting into, people that are engaged in vertically integrated loan sharking or, payday lending for these sorts of things. And if they are going to go to that sort of institution needs to be regulated by the state, which the bonding companies obviously are not for lending purposes. So if you're going to borrow money for these purposes, it probably should be through a legitimate, supervised financial institution. So we would support this change.
Thank you. Are there any other proponent conferees wishing to testify? Not seeing any, then any questions? Senator Corson.
Thank you, Madam Chair. I just want to kind of ask a clarifying question to make sure I'm understanding this correctly. So just let me know if this example tracks. So if a criminal defendant is charged, so a criminal defendant is charged with a crime, the judge sets the bond amount at $100,000, just to use a round number.
Right.
Current law requires that to go to a compensated surety, so to go to a bail bonding agency, that bail bonding agency has to charge me at least $10,000, 10%.
Right, and collect at least $5,000 that up front before posting the
Right,
bond.
and so I have to deliver $5,000 before they can then charge me the full 10%, and then they post the bond.
Correct.
Okay, so what this says though is that to come up with that $5,000, the defendant no portion of that $5,000 can be a loan from the bail bonding agency. It has to be from a bank or some other regulated financial institution.
Right. The bonding company can't take $5,000 out of its pocket, hand to the person, then have them hand the $5,000 back, then they put it back in their pocket.
Okay, I just wanted to make sure that I was understanding that, and that example was helpful, at least for me.
It's just trying to prevent them from circumventing the intent of the statute.
Okay, so they could get the $5,000 from a family member, from a friend, from a bank, from really anywhere else except from the bail bonding agency.
Yeah, correct.
Okay, thank you.
Thank you. Senator Klemp.
Thank you, Madam Chair. That was my question. Thank you. That answered it.
Well, that was efficient. So any other questions? Not seeing any, then thank you very much for your testimony today. Appreciate it. Do we have any persons wishing to testify as neutral or opponent on the bill? Not seeing any, so then we will close the hearing. I'm sorry, I want to, before we close the hearing, mention that we do have proponent written-only testimony at your desk and on the website from Sheriff Jeff Easter, Sedgwick County, on behalf of the Kansas Sheriff's Association, Kansas Association of Chiefs of Police as well. So with that, we will close the hearing on Senate Bill 244. We're going to open the hearing on Senate Bill 157, requiring warrants issued for failure to appear to be provided to a compensated surety, changing the criteria for setting aside bond forfeiture, and requiring remission if the defendant is returned to custody in certain circumstances. And with that, a brief from the reviser.
Thank you, Madam Chair. Senate Bill 157 amends KSA 222807. That's the statute that governs forfeiture of appearance bonds. Current law there in subsection A requires that if a defendant fails to appear and they are charged with a felony, then the sheriff is required to enter that warrant into the National Crime Information Center's index. Usually it's referred to as the NCIC. This bill would add that the sheriff is also required to make a copy of that warrant available to the compensated surety who posted bond for that defendant. Going down to subsection C, current law there provides that the court shall direct forfeiture be set aside upon such conditions as the court may impose. That phrase is stricken in this bill. And it also requires the court to direct forfeiture be set aside if the surety can prove that the defendant left the country. Current law also requires forfeiture to be set aside if a warrant is not entered into the NCIC unless good cause is shown. And this bill would add that it be set aside if that warrant information was not provided to the compensated surety, which is now going to be required under subsection A. And then finally, subsection C in current law requires forfeiture to be set aside if the defendant has been arrested outside of the state and the prosecuting attorney has declined to proceed with extradition. This bill would remove that requirement that the defendant be arrested outside the state and just leave the portion about the prosecutor declining to proceed with extradition. Current law in subsection E provides that after entry of judgment, the court may remit the judgment under the conditions applying to set aside that are outlined in subsection C that we talked about a few of those briefly. This bill would add that the court is required to remit 95% of the amount of the appearance bond if the defendant is returned to custody within 180 days. And I can take any questions.
Thank you. Any questions? Then we will go ahead and invite proponent conferee, a familiar face, Senator Owens from District 31. Please reintroduce yourself just so we can keep our record clear, and welcome back to committee.
Stephen Owens, Senator for the 31st Senate District. And we're trying to kind of break these up into bite-sized pieces, as you've seen, and also be very efficient with the committee's time. And so looking at this, there's a couple of pieces in here just to talk briefly about. One, there's already a law that requires the warrant to be entered within 14 days. But anytime the court orders a bond forfeited, the bonding company or the fugitive recovery agent hired by that bonding company has an obligation to go arrest that defendant. When we go out of state to make that arrest, or I send a team out of state to make that arrest, it really is imperative that we have access to a copy of that warrant. The law enforcement, because we're required by law to interact with law enforcement when we go to make that arrest, they want to be able to see that. They want to be able to have that. And so to be clear, this just simply says that it shall be made available. They're not required to send it to us. It's really on request when we need access to that warrant. The other piece that's important to recognize in the statute is it creates a remission requirement. So simply put, there are a couple of counties in the state that currently say even if you have to pay that bond forfeiture, and let's say, for example, that $100,000 example that you used, if that defendant fails to appear and the compensated surety is unable to arrest that defendant and return them to custody, they have to write that $100,000 check. So that's just exactly how it works. Well, once that $100,000 check is written, we, one, lose authority to continue to seek after that individual, and two, have no financial incentive to seek after that individual. So the thought here is, let's continue to take that burden away from law enforcement for another 180 days. Let that still be our responsibility and still have the motivation to ensure that that defendant returns to court, because currently, once that bond is paid, there's no requirement or no incentive for us to continue to do the work that we do. And so with that, I will yield the remainder of my time to the proponent from Johnson County.
Thank you. Next, we will hear from, again, another familiar face, Shane Rolfe, Vice President, Kansas Bail Agents Association. Please reintroduce yourself and welcome back to committee.
Thank you, Madam Chairman. My name is Shane Rolfe. I'm the Executive Vice President of the Kansas Bail Agents Association. And as Senator Owens indicated, probably won't talk about all of these particular issues. The one issue that's sort of come up on this is the issue of leaving the country. And Obviously, this has become more topical. We had introduced a bill back in 2018 in the first Trump administration to kind of deal with this, as there was an accelerated enforcement on these sorts of issues, and we're back to that again. At the time, back in 2018, when we entered the initial bill, we used the language, if the person had been expelled from the country, to make sure that it was implying that if there was government action to remove the defendant from the country, as opposed to simply left. We're not trying to create a situation where someone can abscond from the country and we say, oh, hey, they're gone from the country, we're not responsible anymore. This would only be, what we're looking for is really only a situation if the federal government steps in, removes that person from the country, and then we have no legal way to get them back. We can't enforce bail bond contracts in another country. If a person has been expelled from the country, it would actually be a federal crime for us to bring them back across the border. So absent any assistance from law enforcement or the prosecutor's office, we would not be able to have them brought back into the country from there without violating federal laws on those. There are several other states that do have provisions of this. I know that I've got in my testimony, I've got notes on it. I think Georgia, Florida, and Colorado all already have statutory remedies for that. If the person's been deported, it does give some relief to the bonding company. We're not trying to find a way where you can get that person out now. I will tell you from personal experience, proving that they've been deported can be difficult. I've had a person who was, voluntarily deported. Basically, ICE came to him and said, "Okay, you've got to go," and he thinks he's doing the right thing. You leave and you check in with the embassy in Mexico City, and once that Mexico City, knows that you're there, we'll close this case and you can reapply for admission down the road because his family was still here. And he thinks he's doing the right thing. His mom puts him on a bus, goes down to Mexico, and of course, 3 weeks later, he misses court here, and I'm like, "Hey, where is he?" It took me 6 months just to get information from immigration that he'd been deported. And we had made a request to allow him to come back in the country to address the charge against him, that sort of thing. And they're like, "No, we're not doing that." But just that process, we had to do a freedom of information request. We had to jump through all kinds of other hoops. So if we don't actually have paperwork from the family showing that deportation, it's going to be exceedingly difficult for us to prove that. And this does require that we prove that the deportation or the left the country has occurred. So I would support Senator Owen's statements on the other two aspects of the bill, though.
Thank you. Do we have any other persons wishing to testify as proponents? Don't see any, so then we'll open it up for any questions. Yes, Senator Bowser.
Thank you, Madam Chair. Thank you for testimony. I guess maybe I'm jumping ahead here a little bit, and I'm looking at the sheriff's proposed amendment has left the country was deported from the country. And then I look at the bill here, it says, so how do you prove someone has left the country? You said it's difficult to, I guess, indicate that they have been deported. How do you prove they've left the country? Is that easier to prove?
No, it's not very easy. My experience, the only way we're able to do that, one, we can request that information from Immigration and Customs Enforcement. Getting that is difficult. We have to file a Freedom of Information request and get that. Probably the best way we've found in doing that, and it's not really a defense to us right now, so we haven't worked really hard at trying to get that, but usually the family that was left behind or that remains in the country or the people again, they oftentimes will have a copy of the deportation order. And so if we can get that deportation order from the family, we can submit that along with our affidavit saying this person's been deported, here's my evidence of that deportation.
So would you be opposed to the amendment proposed by Sheriff Easter?
We have seen that. I think that fits right in line with what we are trying to accomplish with this.
Thank you very much. Appreciate that.
Thank you. Any other questions? Not seeing any, then thank you for your testimony.
Thank you, Madam Chairman.
Are there any persons wishing to testify as neutral on the bill? Not seeing any, then we will invite opponent Conferee Sheriff Jeff Easter, Sedgwick County, on behalf of the Kansas Sheriff's Association, Kansas Association of Chiefs of Police via WebEx. Please introduce yourself and welcome to committee.
Good morning, Chairwoman and committee members. I'm Jeff Easter with the Sedgwick County Sheriff's Office, today representing the Kansas Sheriff's Association and the Kansas Association of Chiefs of Police. I think what Senator Owens and Mr. Rolfe has talked about, we are completely understanding of the fact that if someone is deported from here, that it binds their hands. So as long as we can change the language from has left the country to was deported from this country, we would be perfectly fine with that amendment. The big reason for that is that we have had people that have left this country. All the expenses now are bore by us and the U.S. Marshal Service. And we've had an instance down here where a bonding company took the risk to bond this person out. The person fled, had a warrant for murder. This bill, we would believe, would let the bonding company off the hook for taking that risk. And that's why we're asking for that change. The only other minor change that we're asking for, we do submit every warrant into the NCIC computer so that it's nationwide. We only ask if we can change a copy be given to the bonding companies by the clerk of the district court. It's actually the warrant issued by a judge sent to the clerk of the district court. There's many reasons for that. The clerk of the district court, a lot of times in different jurisdictions, what is their responsibility becomes now the sheriff's responsibility. And so we just ask that that language change to that. But we do agree that bonding companies should have a copy of that warrant because it assists them in doing their job out of state. And I'll stand for any questions. Thank you.
Thank you. Committee, any questions? Not seeing any, then do we have any other persons wishing to testify as opponent on the bill? Yes, please introduce yourself and welcome to committee.
Thank you, Madam Chair. I'm Aaron Breitenbach, Deputy District Attorney in Sedgwick County. I am here representing just the Sedgwick County District Attorney's Office, not other acronyms. I may be here for other reasons, other times. I provided a written testimony that I hope that you have. I want to begin by saying, just as Sheriff Easter said, I'm not here just to say no. I'm happy to be a part of a constructive conversation to make this bill workable, to serve some of their concerns. And some of those have been already addressed. I just want to clarify, when the proponents say that they just want a copy upon request, the language of the bill says provided within 14 days of the issuance of the warrant. So that needs to be clarified. If they just want it upon request, or if they want to say they want it upon 14 days of request, that's different than what's written. So that needs to be fixed. I'll get to the required remission portion in a moment, but I also wanted to address this removal language. Again, the plain language of the bill doesn't say it. It sounds like they're open to the amendment, which will help that. But even in those cases, I believe there should be some showing of due diligence on their part. When someone is in custody, particularly in Sedgwick County, and you go to the website and you see that they're in custody, guess what? You see that there's an ICE hold. If you bond that person out and they get deported, I'm sorry. I think the bonding agent is responsible for that person no longer being available to our office to prosecute. I recognize they can't know when every person is documented or not, or when a lawful resident might be subject to deportation, and those are things that can play out through litigation. But to just say, well, they got deported, so I'm out, when it was staring them in the face, when they've been deported previously before, or they can't provide any documentation or things of this nature. The problem is, and I've set forth some examples in my written testimony of people who are convicted with heinous crimes, murders. They're going to want to leave. And they're going to, and an unscrupulous bondsman, and to be clear, I support the bonding industry. I recognize the important value they provide to our communities to regulate our jail population and to allow people the opportunity for pretrial release. It is important. But as was testified to about another bill, there are some bad actors. And if I know I can negotiate some amount of money from you, you know you're going to get deported, and I'm going to pocket whatever I got from you without any risk of paying anything, you can see how that can be abused. So I think to protect the good actors, they should be able to show, hey, when I bonded him out, there wasn't an ICE hold. He was a lawful resident. He showed me a Kansas driver's license. Something of that nature that would show that that they were dealing in good faith with the court when they signed that bond, promising to bring that person back. And that's all that we're asking for. And I think this bill can accomplish that with some of the amendments that we're talking about. There was one other that came up as they were testifying. Oh, that amendment to, I guess it'd be CD, big D, just to provide some
We
context.
have 1 minute remaining. So.
Thank you, so I'll be brief. Just to provide, actually, you know what? For now, I want to get to the required remission. The request for 95% remission, I think, is particularly important given that they are required to get 10% up front. So what they're saying is, we make a 5% profit even when we don't produce the person in court. In Sedgwick County, we have a stair-stepped remission process where if they produce the person within the first 30 days, they get 75% back. Within 60 to 90, they get 50% back. You know, I can't remember all the permutations, but the courts have the discretion to remit. And I think it would be fair to them to codify that process to some degree. I just think 95% is asking too much. And so I would ask the committee, and when it works the bill, to look to Sedgwick County or other large jurisdictions that deal with these issues regularly for some guidance. Thank you. And
Great.
I'll stand for questions as you wish.
Thank you, and apologize we didn't get that testimony distributed. We have located it, and it is now on the website, I believe. So it's getting put on the website. But with that, do we have any questions for our opponents? Not seeing any, then with that, we will close the hearing on Senate Bill 157. We're going to open the hearing on Senate Bill 188, requiring a secured release for release prior to trial when a person is charged with certain offenses and creating a mechanism for unsecured judicial release. And with that, a brief from the reviser.
Thank you, Madam Chair. Senate Bill 188, as you can see in front of you, it amends a lot of statutes, but I'm going to point you to Section 11 because that's really where the bulk of the substantive changes are, and this is in KSA 22-2815. This is the statute that sets the procedures for releasing a person on their own recognizance, which is a term you've probably heard. An OR bond is usually how it's referred to. This bill changes the phrasing to being released on an unsecured judicial release. And then it also adds a list of crimes for which a person would not be eligible for unsecured judicial release. Those are capital murder, murder in the first degree, murder in the second degree, kidnapping, aggravated assault, aggravated battery, aggravated robbery, rape, criminal sodomy, aggravated criminal sodomy, aggravated sexual battery, and aggravated indecent liberties with a child. All the other sections that are being amended in the bill are really just changing that reference to on a person's own recognizance or own recognizance, personal recognizance, all of those statutes throughout the statute books to refer to it now as unsecured judicial release to match the name change in this statute. And I can take any questions.
Thank you. Is the list of crimes that you stated, those are currently available today without the bill to be released on your own recognizance without any bail being paid? Is that the status quo?
Madam Chair, I hesitate to, right now there's no list of crimes at all about whether someone can be, whether they require a bond or are released on their own recognizance. It's up to judicial discretion in each of the judicial districts. So, I'm sure that there are localities who have, bond schedules that prohibit that, but the statute itself doesn't prohibit that.
You could be released without bond for those crimes you listed, the aggravated battery and aggravated assault and...
So like I said, nothing in the state statute on own recognizance programs prohibits that.
Okay, great. Thank you. Any other questions for the reviser? All right, then we will hear from a familiar conferee as a proponent, Senator Owens from Kansas Senate District 31. Go ahead and please reintroduce yourself.
Absolutely.
Thank you.
Thank you, Madam Chair. Again, bite-sized pieces here. Stephen Owens, Senator of 31st Senate District. So I have long advocated that there are some crimes that it makes sense to use an own recognizance bond or personal recognizance bond. And just for clarification, what that is simply a promise to appear in court. Okay, so there's no compensated surety involved. There's no payment. There's no security involved. It is simply saying, I promise I'm going to appear in court. Well, what we have seen, and there is a tremendous amount of information, I'm happy to share specific examples, is where a dollar amount is affixed to an own recognizance bond. And so you'll see in my testimony where it says a $50,000 OR bond. There are judicial districts that utilize that, yet that $50,000 is truly meaningless. Never have I found a case where someone has failed to appear and the district attorney or the judge has actually collected on the dollar amount on that own recognizance bond. And so what we're stating here, simply put, is instead of, calling it a $50,000 OR bond, we should call OR and PR bonds uncompensated judicial release, because that's really what it is, right? It is a judge choosing in their discretion, so we're leaving the discretion in there, to release that individual on an uncompensated judicial release. So simply put, that's just clarity for the citizens of the state of Kansas in ensuring that there's no dollar amount, attached to one of these OR or PR bonds. And so changing that terminology, I think, is important. The other thing is, when we're looking at public safety, I think we could all agree and find consensus on some of these really high-level crimes that should never qualify for any kind of, uncompensated release, uncompensated judicial release. And in many instances, they need to remain in jail, and ensuring that the judicial discretion is utilized in setting those bonds and ensuring that we're not seeing, I saw a $400,000 OR bond on a rape charge a few years back, right? It's out of line. It's not what the citizens of the state of Kansas expect when they expect accountability in our criminal justice system. And so with that, Madam Chair, I'll stand for questions.
Thank you. We're going to go ahead and hear from all the proponents, and then we'll take any questions. And another person familiar to committee, Shane Rolfe, Executive Vice President, Kansas Bail Agents Association. Please go ahead and reintroduce yourself, and welcome back.
Thank you, Madam Chairman. My name is Shane Rolfe. I'm the Executive Vice President of the Kansas Bail Agents Association. We do support this. In all honesty, our concern is this doesn't necessarily go far enough in limiting the use of signature bonds, whether we call them unsecured judicial release or whether we call them signature bonds. Senator Owens was correct. There really are meaningless. Chad Taylor actually testified before the legislature years and years ago, the former district attorney in Shawnee County, that it was a meaningless amount. They never collected it. Oftentimes they didn't even bother to try and pursue them because they knew there was nothing coming down the road. So, but we have had this drumbeat of so-called bail reform over the past few years where, there's been an argument over and over again that despite the fact that bail is specifically referenced in both the U.S. Constitution and the state Constitution, that somehow bail itself was unconstitutional. Those issues have been put to rest. The Dobbs decision by the Fifth Circuit basically kicked those cases all out ultimately and said these should have never been filed in federal court. If you want to alter your bail system, you need to go to your state legislature and get them to alter it. Bail is not unconstitutional. I do have some concerns about the language here in that I think we might have misplaced, if we're trying to limit the use of signature bonds or unsecured judicial release, in certain cases, the statute that has been placed in 22, 28, 14, and sequential, those all have to do with pretrial release programs. Those are release without bail programs, and you're putting into a supervision thing. This would still, would allow the court to give a signature bond to an accused murderer, for instance, as long as they weren't being put into a supervised release program. They could simply still do that. I think if we were going to go with this, we'd want to make some references in there to make sure that it applied to all unsecured judicial release, not simply only ones that were placed into a pretrial release program. So my testimony is there. I don't want to bore you with all the details of what's happened. I know that, like I've referenced, Harris County, Texas, was where the Dobbs case was. They initially entered into a settlement agreement where they were required to release all their misdemeanor cases. And following that, their failure to appear rate shot up to 80% or more, depending on whose numbers you look at. and their conviction rate fell to 15%. So I mean, there are consequences to simply letting everyone go. You will see a increase in failures to appear. Generally, you'll see an increase in crime that accompanies that. There's been arguments and studies back and forth as how much that actual number is, but I think we've all seen the news over the past few years of what's been going on here. So it is important to make sure that we limit the use of this and that we don't just wholesale release people without some sort of assurance that they'll be back in court. So I'll finish up there.
Thank you. Committee, any questions? Yes, Senator Schmidt.
Thank you, Madam Chair. I guess I have an overall concern about what we're hearing today, that we spent maybe about the past hour talking about issues that have a pecuniary interest with one of the members of our body. I'm sure the intention is here, but I'm concerned about the appearance of self-dealing here with some of these bills. Also, I guess for the Harris County, the Dallas Harris County, I hope that we'll find that. I saw Harris versus Jackson.
No, it's Dobbs v. Harris County, Fifth Circuit.
I just have trouble finding that.
I would assume Google Scholar would have that. There's also a case, Daves, D-A-V-E-S, that was done out of Dallas County. The Fifth Circuit also addressed the same issues on that. I don't have the actual case site, but there's dozens of, if you just simply go to Google Scholar, I'm sure LexisNexis has it as well. Okay, if you go Dobbs v. Harris County or just Dobbs Fifth Circuit, it should pull up. There's several entries on there. I'd be happy to provide you with the actual case sites and everything, after the hearing.
Okay, thank you. Again, thank you for allowing me to reach my concern. I'm sure.
Thank you. And it's a public hearing, so we invite conferees from all walks of life, and it's important, especially when we have experts in the industry field. We appreciate hearing that testimony as well. So with that, question from Senator Titus.
Thank you, Madam Chair. So when you look at this bill overall, I guess whether or not there's a dollar amount attached to a own recognizance bond or not, can you explain why that would matter to the public at the end of the day? I mean, why is it worth the trouble to change that? I mean, the judge has the discretion to require the payment or not, so it seems kind of like semantics.
And it is, to a certain extent. Calling it unsecured judicial release versus OR bond there's a certain semantic aspect to that. But if you look at the news on these things, and you'll see these horrific news stories of people that have been released on bond and have gone on to commit additional crimes, and the news will simply report that they're on bond. And so then when you go back and look at that, well, it turns out it was a signature bond. And they weren't actually on any sort of secured bond at all. But we still then bear the brunt of that and go, well, why did this person ever get out in the first place? How were they given a bond? That sort of thing. Clarifying unsecured judicial release basically says this is what it was. It was not a release on bond. They're out, and the court clearly has the authority to do that. But yes, it is a semantic argument on that. We would, in all honesty, would like to see, go beyond that to where there were additional restrictions on who could qualify for those. But as it stands now, there is a semantic argument on that, yes.
Thank you.
Thank you. Other questions? Not seeing any. Then are there any persons wishing to testify neutral or opponent to the bill? Yes. Please come up and introduce yourself and welcome to committee.
Hi, I did submit written testimony. I think the snow day, because it was late and it was a snow day, so, but I just wanted you to know that there is written testimony that I provided in a neutral capacity. So again, for the record, my name is Jennifer Roth, and I'm a member of the BIDS Legislative Committee, and I am here as a neutral conferee on this bill. I'm going to, because knowing that I'm going to refer to my testimony a little bit here, but there's basically 4 points I wanted to make. The first is that as written, SB 188 covers more than just high-level crimes. You'll note that it includes every form of aggravated battery, which ranges from severity level 3 to severity level 8, and 8 is the third lowest thing on the grid. In fact, if you count attempts, it would cover aggravated batteries to the very lowest level of the sentencing grid. That means that people who are presumptive probation or eligible for a border box finding for probation would be denied release unless they pay a surety or pay cash. People that are criminal history, if you can picture the grid here, people that are C through I would fall into a presumptive probation box if they were charged with level 7 aggravated battery or level 8 reckless battery. They'd be presumptive probation. The same with aggravated assault. 97% of the aggravated assaults that resulted in conviction were level 7s, and level 7 is presumptive probation unless a special rule applies. So I just wanted to be clear, this is not all level 1s or off-grids. Oh, and by the way, this also would count for people after they've pled. So I don't actually know who else is a conferee, but I'm a little bit surprised that people who run jails and are prosecutors or judges wouldn't be concerned by this as well. Because, for example, 368 people were put on probation for all forms of aggravated battery in 2023, according to the Sentencing Commission. And that would be 368 people who perhaps there was an agreement that once you plead, we'll let you out because we know you're presumptive probation or there's a recommendation, but they'd have to pay money to get out. So that seems like a real problem considering how our system runs on plea bargaining. The second point I want to make, oh, that was my second point, is that this would apply to people once they've pled. The third point I wanted to make was I literally did not put together this for 26 years until I was sitting in the back and reading part of the pretrial release report that I talk about in my written testimony. It didn't occur to me until just now that I know this part. The purpose of bond is to ensure somebody's appearance in court and public safety. Yet when a surety takes on a bond, the only way they lose money is if the person doesn't appear. So if we want to expand, it sounds as though the proponents wish that this goes further and that more people would lose access to unsecured judicial release. But interestingly, they will never lose money for that. So the examples of people who, once they're released, do something that's against public safety, that will not result in the forfeiture of a bond to a surety. So I think that is an interesting thing to keep in mind. And what we do know is that keeping people locked up while they are presumed innocent can actually hurt public safety. Oh, sorry. In that they lose jobs, they lose their housing, they lose their family supports. It's harder to mount a defense, to prepare for your defense, and so on. And my last point would be that this is taking, again, there's some of these offenses on here that are hard to argue with. I'll give you that. But there are all kinds of situations in this world, and by passing this and taking discretion away from our local judges, then they are not able to assess what that community needs or that person needs. So I'd be willing to stand for any questions.
Thank you. And committee, is there any questions? Any questions? Yes, Senator Haley.
Confirming that you're appearing as a neutral on this?
Yes, I know. That didn't sound very neutrally, which I will give you that. And again, in my written testimony, I do say it is hard to argue with some of these offenses, but I want to be clear that some of these are not high level.
All right, thank you. Thank you, Madam Chair.
Committee, we do have the written testimony on the website at this point, and I'm going to blame the snow event yesterday because we're very thorough on getting that testimony when it's the appropriate time to put it on the website. So we're going to then close the hearing on Senate Bill 188. We have already finished with our proponent conferees, so we're going to close the hearing on Senate Bill 188, and we do have some time, and I would like to work a bill that has been heard, and I think there are amendments ready, Senate Bill 70. And if we could have a brief reminder from the reviser about Senate Bill 70.
Thank you, Madam Chair. Senate Bill 70 provides for reasonable fees for electronic copies of records under the Open Records Act. It also exempts from disclosure formally closed investigations with no found violations. It requires the county or district attorney to file reports of violations with the Attorney General in December instead of January. It determines the membership calculation of subordinate groups under the Act. It also requires public bodies or agencies that live stream meetings to ensure that the public is available to observe all portions of the public meeting. And then it allows for a 5-minute deviation to resume an open meeting at the conclusion of closed or executive sessions.
Thank you. Committee, any questions for the revisor? A discussion on the bill. Are there amendments? Yes, Senator Shane.
Thank you, Madam Chair. Just check with the revisor to see, do you have a copy of my proposed amendment? Okay, perfect, thank you.
Would you like her to pass that out?
Yes, please, and while she's passing it out, this is a simple amendment on page 12, line 20, that changes, right now, the bill in front of us would change the statute to say on or before, instead of on or before January 15th of each year, our original bill draft said December 15th, and this amendment would amend December to October 15th of each year.
Any questions for the, well, let's have a motion then.
Madam Chair, I move that we adopt the proposed amendment.
Is there a second? Yes, Senator Reichman. Committee, any discussion on the motion? Any questions for the carrier? Not seeing any, then you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, nay. The motion carries. We're back on the bill. Any amendments or further discussion? Senator Titus.
Thank you, Madam Chair. I have an amendment, if Natalie could pass that out. Did we split it?
Do you want to explain your amendment or have the revisor?
I can explain. So this amendment relates to some testimony we heard about confusion over fees, and what the attempt to do here is just clarify that an agency can only charge a per-page fee, or they can charge for the time to collect, but they can't do both, and you can't charge a per-page fee for digital records. So if an agency is going to charge for digital records, right, so we're talking PDF of something, you can only charge for time collected, which I would expect to be the most common method this is done. Or you have the option to just charge, if you're just running copies, you can charge the 25 cents per page or up to that amount. So I think there was some ambiguity in the way this was written, and I just wanted to make sure those lines were clear. So I would move adoption of my amendment regarding fees.
And I'm going to change our process just a little bit. So before I ask for a motion, let's ask for any discussion first. So I should have done that with the last amendment we had. But is there any discussion or question about the amendment? Not seeing any, then is there a motion? Go ahead, Senator Titus.
I would move my amendment.
Is there a second? Senator Rose, any discussion? Not seeing any, then you all have heard the motion, and all those in favor signify by saying aye. Those opposed, no. The motion carries. We're back on the bill. And Senator Titus.
And one more. And I'll explain. The intent on this amendment is to clarify some language that was put into the bill as new language, and this was based on some testimony we heard. My ultimate concern is that an agency may attempt to create a body that is not subject to the Open Meetings Act by putting a number of members in that subgroup that are not part of the regular board. It's my belief that any entity created to discuss policy by a publicly elected entity or agency needs to be part of the Open Meetings Act. If people would like notice of those meetings, they should be able to get it. And by stacking the membership, you shouldn't be able to hide those discussions and recommendations from public view. So this amendment just clarifies that if you have a subcommittee or subordinate group, it's subject to the Open Meetings Act when there's at least a quorum meeting.
Thank you. Committee discussion on the amendment. Senator Corson.
Thank you, Madam Chair. I definitely support the thrust of the amendment. My only question would be, and I am thinking the answer is probably no, but I want to clarify that. Are we instituting something that is going to cost money for these local units of government to provide notice, or is it sufficient that they just provide maybe like an electronic notice on their website? I just don't want to inadvertently burden them with something unless that is our intention. I think it's probably not, but I wanted to clarify.
Thank you, Senator Titus.
Thank you, Madam Chair. That's correct. You know, the current requirements for notice of a meeting is that reasonable notice be provided. So whatever the normal course is, there aren't really any specific requirements other than if somebody asks to be notified, which could be done via email. That's the only real affirmative requirement that I'm aware of, and Natalie could clarify if I've described that wrong.
Any further questions? Oh, sorry, Senator Shane.
I guess not so much questions, but discussion. Senator Corson, to your point, the only potential change in practice I would see for a local entity is that they would need to post these meetings from a smaller group on their website or by whichever normal means they communicate their open meetings. So it would be a little bit of a change of practice, but I do think it's important, and I thank Senator Titus for bringing this amendment, because we do know that sometimes entities will coordinate these smaller groups or these subcommittees where there's meaningful discussion held on policy without action taken on the policy, and sometimes the conversation around that policy is also important for the public to see. So I fully support this amendment and thank Senator Titus for introducing it.
Thank you. Further discussion or questions? Not seeing any. Do you want to move your amendment?
I would move my amendment.
Is there a second? Well, we had Senator Shane speak to it, so we'll let him go ahead and second it. Any further discussion? Then you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. We're back on the bill. Any further discussion or amendments? Not seeing any, then I will entertain a motion. Yes, Senator Bowser.
Thank you, Madam Chair. I make a motion that we move Senate Bill 70 favorably out of committee as amended.
Thank you. Is there a second? Senator Shane, any discussion? Not seeing any. You all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. Committee, I would like to also work Senate Bill 138 and 138. In fact, we just heard yesterday, if we could have a reminder from the reviser.
Thank you, Madam Chair. Senate Bill 138 requires search warrants to be issued only on statement of facts sufficient to show probable cause that are made by a law enforcement officer.
Any discussion, amendments, or a motion? I'll let you have a minute to pull your paperwork out. Oh, sorry, we caught our committee assistant off guard. Apologize. Yesterday, committee was on WebEx, so we didn't have our paper folders at our desks. So, and that was yesterday due to the weather impacting travel across the state. If you've had an opportunity to review the bill, we'll open it up for any discussion or amendments or a motion. Senator Titus.
Thank you, Madam Chair. I would move that we recommend favorably for passage Senate Bill 138.
Thank you. Is there a second? Senator Klemp. Any discussion? Not seeing any, then y'all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. Committee, I wanted to let you know that we're, I think, letting opportunity for amendments to work their way through on a couple of bills, and I wanted to let you know that we might be looking at these following bills to work tomorrow or Monday, and that would be Senate Bill 54 regarding third-party funding of litigation, and that would be Senate Bill 127 regarding expanding the hearsay exception for statements made to a physician to all healthcare providers. 128, creating an exception to certain mandatory reporting obligations for licensed social workers. And 157, which is what we heard today, regarding warrants issued for failure to appear to be provided to a compensated surety. It sounded like maybe some amendments were coming on that. 186, requiring probable cause affidavits to be made available to law enforcement agencies prior to the execution of a warrant. And 188 is what we heard today, requiring a secured release for release prior to trial when a person is charged with certain offenses and creating a mechanism for unsecured judicial release. And then we also heard 244 today, prohibiting a compensated surety from making loans for certain portions of the required minimum appearance bond premium. So that might be some of our work tomorrow and Monday. So if you have amendments, discussion, questions, please be ready for that. And we will hear 3 bills tomorrow as well. So expect us to be busy, and thank you for your attention and your work. And with that, the meeting is adjourned.